Well, hello, welcome to the second class. This should be probably around page 2 of your handout. In this class, we're going to go over some of the basic differences between the different types of intellectual property that I talked about in the first class. So let's start with patents. The first type of patent is a utility patent. A utility patent, again, protects the function of an item. These patents are the most expensive, the most time-consuming, and in most cases give the inventor the best protection that he or she can have for their money. Now, a utility patent, because it protects the function, has to be very well written and is usually involves some detailed drawings that show the various aspects of the patent. It also has to have claims. Usually there are 20 claims in a utility patent application. Now, these are the most expensive type of intellectual property that you can apply for. And most utility patent applications are examined anywhere from little under a year to maybe 2 years after you file. And once they're examined, it'll often take an office action or two before you have a real shot at getting a patent. Now, the allowance rate for utility patents is much lower than that for design patents. I'll talk about them next. Utility patent application rate success has ranged anywhere from 38% up to around 70%. Right now, the USPTO seems to be around 50% of applications eventually turn into patents. Now, you can obviously enhance your chances there by getting a prior art search done first, and I'll be discussing prior art searches in a later video. So after you wait a year or two to have your patent application examined, and after it goes to an office action or two, hopefully you end up with a patent. Now, a utility patent is going to be good for 20 years from the date of filing. And since I've already told you that it's going to take 2 or 3 years before you really have a shot at getting a patent, a lot of inventors at this point just say, well, you know, that means I'm only going to get 17 years of useful life of my patent. Well, that's true. And they freak out and they think, well, you know, my idea is way too valuable to just protect for 17 years. And for these people, I want to say that, first of all, in my experience, once you have an idea, you generally have 5 golden years to make money from it. And so if you want to sit on your idea for 10 years and then file for patent protection on it, by the time that 10 years is up, odds are somebody's invented a better version of what you tried to invent, and your idea may no longer be marketable. So my suggestion is that rather than worry about whether your patent is going to expire 17 years from now or 16 and a half years from now, instead you should really be worried about whether you're going to make money and how you're going to go about making money. The second figure I'd like to throw out is that over 50% of the money that's made in the American economy off products is made off products that are fewer than 2 years old. And so again, once you have an idea, you have a certain limited amount of time to try to turn that idea into money. If you wait on it forever, again, somebody else is going to come up with your idea or something even better. They're going to patent it and you're going to be out of luck. So the second type of patent that we have is a design patent. I shouldn't say we, it's not like I'm the US Patent and Trademark Office, but the second type of patent out there is a design patent. And a design patent protects the shape of an item. And as you can probably figure out by now, protecting the shape is usually not as valuable as protecting the function. Now, with design patents, they're usually examined more rapidly than utility patents. I used to tell people somewhere between 7, 9, 12 months was average, but lately I've seen some that have been dragging out to a couple of years. So design patents take a while to be examined as well. They're much less expensive than utility patent applications because they're much easier, frankly, for the patent attorney to prepare, and they have a much higher success rate. About 95% or higher of design patents end up being granted as patents. If you do get a design patent, it'll be good for 15 years from the date of issue, so roughly 2 years or so less useful lifetime than a utility patent. But again, focus on making money off your invention, not worrying about when your patent may be expiring. Now, a lot of people ask, well, why should I get a design patent or a utility patent? Can I get both? Yes, you can get both a design patent on something and a utility patent on something. Reasons people go for design patents rather than utility patents. First and foremost, a lot of times the prior art shows that there's no way you're going to get a utility patent on the function of your item, but if your item has a different shape, you can probably get a design patent on the shape. Like right right up here are a whole bunch of wheel design patents that I got for one of my clients. Now, obviously, getting a utility patent on a piece of metal that attaches an axle to a tire is probably not going to work because that's been around since bicycle tires in the 1800s, and certainly since Ford Motor Company began making cars in the early 1900s. So we can't get a utility patent on just a piece of metal that attaches a tire to an axle, but we can get a design patent on a whole bunch of different shapes of it. And so, that's one reason why you may want to get a design patent instead of a utility patent. That the prior art shows you just don't stand a chance at getting a utility patent. The second reason is frankly financial. A lot of small businesses, they look at their budget and they don't have the $6,000, $7,000, $8,000 to $12,000 it's going to take to get a utility patent prepared, and then the extra $3,000 or $4,000 it often takes to get that patent rammed through the USPTO's U.S. Patent and Trademark Office, so you finally get a patent at the end of it. Now, for a lot of people, they understand that the function of their item is the most important thing for them, and yet they maybe don't have a finished design. One problem with utility patent applications is you have to write that with claims that specifically point out what you're claiming, the important part of your invention. Now, with a lot of inventors, they'll have an invention, but they really won't understand completely how it works. They won't have a finished model. They'd really like to talk to an engineering firm or get some prototypes made, or maybe show their invention to a focus group, or maybe talk to investors, but they're scared to let their idea out in public. And so for them, there's something called a provisional application. Now, provisional application is kind of like a junior varsity version of a utility patent application. Well, first of all, they're about half the price. You can prepare them fairly quickly. Usually we're 7 to 10 days to prepare a utility patent application, run it by the inventor, have some back and forth, and end up with a provisional application that makes both of us happy. So with a provisional application, you get 1 year patent pending status. And during that year, you're just as validly patent pending as if you filed the full utility patent or you filed a design patent or both. Now, what the patent pending status allows you to do is within a year of your provisional application filing date, if you file a utility patent application that effectively reaches back and grabs that provisional filing date, you can do something called claim priority, and the filing date of your utility patent will be the same filing date of your provisional. And so this allows you to take your idea and get a provisional file, go out, shop it to investors, shop it to R&D, see if they'll take you on Shark Tank, make a bunch and sell them, basically do whatever you want. And then before the year is up, you have to have a utility patent application filed that claims priority back to the provisional. Now, provisionals sound perfect, and when used properly, they can be really good, but there are some drawbacks. First of all, the USPTO examiner, when he or she looks at your utility patent application that claims priority back to that provisional, he or she is going to look at the provisional and determine whether the provisional offers adequate support for the subject matter of the utility. And so I run into this problem a lot. People try to go online with, www.elcheapoprovisionalpatentsfor99.com or something like that, and they come into our office and they say, well, I got this provisional done for $99. What kind of a discount are you going to give me on my utility patent? Because somebody else all did the work. And the majority of these times I look at it and say, well, you got two problems. First of all, there's no way this provisional as it's written is going to support a utility patent application. And second of all, I sure hope that you didn't disclose your invention based on this provisional feeling that you're safe, because you really weren't safe. So the first thing is the provisional has to be well written so the examiner can look back and say, yeah, back at the provisional date, this inventor knew what he or she was filing on at the utility date. You have to make sure that you file within a year. Provisionals are only good for a year. After the year is up, your time's up, you have lost the chance to go back and file for a priority date based on a provisional. So that's kind of the intersection between utility patents, provisional patents, and design patents. Okay, let's go over trademarks a little bit. Now, as I said in the last class, the goal of patents is to protect the new design or the new way that something works. It's basically to protect an invention. And without patent law, there'd really be no reason to be an inventor or a scientist or researcher, because whatever you invented, anybody else could use. The goal of trademark law is twofold. First of all, protect the consumer. So if you're buying a product with a certain brand name on it, you know it's from that brand name. The second thing is, if companies that make products are held accountable for their products, they're probably going to do a better job. So let's go over trademarks for a bit. So trademarks are fairly inexpensive to prepare and file. And again, you can file them on the name of a company, the name of a product, on a logo, a slogan, a tagline. You can also file on a bunch of really funky stuff that I'll be going over in a future class. But for most average people, people who are doing things a little more simple than, say, filing for a trademark on the smell of racing vehicle lubricants. Yeah, right. That's actually a trademark. You're talking about the name of your company, the name of your brand, name of a product, something like that. Now, for trademarks, they're usually examined within 4 months of filing. So they get examined a little more quickly than do patent applications. With trademarks, I'm going to be going over in a future class the characteristics of a good trademark, something that might be trademarkable. In general, you want to stay away from things that describe what you do. So, for example, if I was calling my law office the Carlsbad Law Office, that would be something you'd probably get rejected because it merely describes what I do and where I do it. So you want something a little bit more fanciful or arbitrary. But again, we'll cover that later on. Now, once you get a trademark examined, again, you can have a trademark search done if you want ahead of time. I don't do patent searches or trademark searches with my, frankly, ridiculous hourly rate. You'd never want to pay me to do that kind of stuff. But if you want to, just send me an email, eric@iciplaw.com, and I'll send you the name of a couple people who do patent searches, patent illustrations. There's a good company that does trademark searches for $250, so I can send you that information. Anyway, so with trademarks, once the trademark is granted, and usually trademarks, if you've had a trademark search done, have about a 2/3 chance of success. Once a trademark is granted, unlike a patent that has a natural expiration date, trademarks can be extended indefinitely, and which is kind of good because, if you're a big company, you're putting a ton of time into marketing and advertising, you're Microsoft, and 5 years after you get your trademark, somebody tells Bill Gates, well, Bill, I'm sorry, but anybody can call their products Microsoft now, but thank you for building up this great demand for Microsoft products. Sorry, Bill, you lose. Bill would not be very happy, and I wouldn't blame him. So with trademarks, you can extend them potentially indefinitely, but you have to pay the maintenance fees, and maintenance fees are due in year 5, 19, 29, 39, 49, 59, etc. So essentially you have to pay a halfway through the decade maintenance fee, then you have to pay another one at the end of every decade. Fortunately, they're not that expensive, but if you have a trademark, you got to keep using it. I run into situations an awful lot where somebody has a trademark and they really haven't done anything with it, and then they want to renew it. Well, okay, I need a specimen to submit to the USPTO to show them that you're still using it. So you got to be using it. So keep using it. The other thing is, if you get a trademark on a logo or a certain font or a color, that trademark is good only for that logo, that font, or that color. And so if UPS got a trademark on the gold and brown UPS sign, and then they changed it to pink and green, well, they'd have to get a new trademark on that because their trademark is on the brown and the gold logo, not the pink and the green logo. So anyway, if you change it, you really have to file for a new trademark because your old trademark will not protect the new look anymore. Okay, copyrights. Now, copyrights in the old sense were based on playwrights such as Shakespeare and people like that, music composers, who felt that if they had put their time into building houses or growing a cattle herd, it's something they could leave to their heirs, whereas if you wrote a play and everybody could perform the play, well, that's kind of not very fair. So copyright originated hundreds of years ago as a way to protect artistic creations. And until recently, it really protected artistic creations. But in the last 20, 30 years, we've had this little thing called the internet show up, and web pages show up. And since then, the copyright law has been extended to protect a lot of things that you need in your everyday business. So I always suggest that even if you're an inventor, if you have a small business and you're never going to write a song, or you're never going to create a poem or anything like that, that's fine. But you should consider copyrighting your website, your owner's manuals, any sort of instructional manuals that you give away with your product. Perhaps you think about copyrighting your packaging. Basically anything that has an artistic creation component to it would be worth getting a copyright on. Now, a lot of people, and I'll go over copyrights more in a future class, but a lot of people say, well, I created something, I don't have a copyright on it. Well, you do, but it's not a very enforceable copyright. To get an enforceable copyright, you really have to register it with the Library of Congress, and they're right across the river from the U.S. Patent and Trademark Office. So anyway, with copyrights, they're good right now for the life of the author plus 70 years. Probably once Mickey Mouse and Steamboat Willie become in danger of becoming public domain, it'll be extended to life of the author plus 90 years. So anyway, copyright certainly for me is plenty of protection for anything that I've created, because I don't think it's going to have a whole lot of value 70 years after my death. But if you happen to be, Stephen King or John Grisham, or some famous the Sony Pictures or somebody like that, your creations probably will have some value 70 years after the death of either the person who created it or the organization that funded it. So anyway, copyrights for inventors, you should think about your website, owner's manuals, packaging, things like that. Any pictures, photographs you take, any written content, that all can be protected by a copyright. So this concludes lesson 2. Hope you've learned something from it. We'll go more in depth on each of these topics in future lessons. Thanks for watching.